Good evening, everyone. Glad that you could join us in this particular session of the webinar put on by the Sustainable Forestry and Land Retention Project here at Roanoke Electric. I'm Alton Perry. I'm the program director, and we're glad and honored to have with us this evening two professionals, legal professionals out of the legal profession to help you navigate through the issues of estate planning and heirs property. Also would like to make sure that at the end of this session, there'll be a short survey that we'll ask you to take about 5 or 6 questions. If you would please take that survey for us so we can gather the information which is important to provide back to our funders and partners. So without further ado, Mavis Craig and Pamela Harrigan-Young will have opportunity to go through all of their presentation. So Mavis and Pamela, you can take it away.
Hey everyone, great to be here. So Pamela and I refer to this presentation as Strong Roots, New Growth, and we are going to talk about heirs property and estate planning basics, as Alton mentioned. Thank you in advance for everyone sending in questions. We have received a lot of great questions that we look forward to responding to. We won't be able to answer every question directly. However, I do think based on the questions and the presentation that we prepared, that you will get, a lot of you will get answers to your questions, and then there are some that we can address directly. So a little bit about us. Pamela, you want to share about yourself?
Yes, certainly. Okay. Good evening, everyone, and thank you for the opportunity to present this evening. We're looking forward to sharing what we hope will be helpful information. I am an attorney and a CPA, and I have 2 different practices. My law practice focuses on estate planning and estate administration, as well as heir property and elder law issues. And my CPA firm focuses on tax preparation and tax planning. And I certainly have a passion for preserving wealth through reduced taxation and then transferring that wealth to the next generation. So I'm happy to be here to present with you all.
And again, my name is Mavis Gregg. I'm the director of the Sustainable Forestry and African American Land Retention Project. Similar to Pam, I am a lawyer and had the opportunity to have my own law practice where I worked with from Roanoke, SFLR landowners, which was an honor. But my real estate or my law practice has always centered around real estate. And when my family or when my siblings and I became heirs property owners ourselves, it really made me think about how I use my skills and experience to help others maintain and grow intergenerational wealth. Surprisingly, forestry has been a great opportunity, similar to what it's been for you all. It was a great opportunity for me in doing this work. So very excited to be here. Always great to see the REC crew and, of course, Bob at NC State. So I'm looking forward to this discussion and our discussion tomorrow. Just to cover what we are going to talk about today, we will have a discussion about heirs property. We'll look at what it is, how do we address the challenges related to heirs property, incentives and initiatives for heirs property preservation. And then we'll take a closer look at how you can plan for your family's land and the rest of your estate. Pam is going to guide us through estate planning and what are some really important things to think about and actions that you can take to create or to move towards a good estate plan. So those are our topics for today. We'll get started with heirs property. I do want to encourage you to use the chat box to respond to some of the questions that we asked today. This is interactive. And I'll ask Alton and Pamela to take a look at the chat box while I'm presenting. Let's get started. So first of all, as many of you may know, heirs property refers to land that's owned by multiple people, each of whom have inherited their share. So whether you have a will or not, if the property has been inherited from a family member, then it's considered heirs property. And so that's important for us to all think about. It's also important for us to understand how ownership of property transfers. There's two ways that you can transfer ownership of real estate. Does anyone know? And you can use the chat box feature, but what are the two ways to transfer real estate? In fact, some of you talked about one of the ways in your questions. There's a lot of questions about one of the ways. Deeds and wills. Okay, so if you said deeds, that's correct. And the person who said wills, let's take that a step forward. When does a will become effective? What is the action that requires a will to become? Yes, death. I don't know why I said that so, like, it was so exciting. Yeah, so two ways to transfer in real estate, deed and simply by dying. So we know it happens when people pass away. When people pass away, their ownership of their real estate transfers automatically. In North Carolina, when you pass away owning real estate, the real estate ownership transfers on the date of death. And that's significant because that means the new owners take over. And when we have property transferring by virtue of someone dying, there's no automatic creation of a record of who becomes the owners of their real estate. Instead, families have to go through the estate administration process where you're making an application, you're listing out the heirs, and then completing that process to inform the public of many things, including who inherited the real estate. But many families do not do that process. And with heirs property, what we often see is that there's not a lot of documentation, including estate administration, to demonstrate who became the owners of the property. Contrast that with a deed. A deed is a legal instrument that that informs us of who owned the property and who they transferred ownership to. So it lists the current owner, and then who's named the grantor, and then the grantee is the new owner or owners of the property. There's a legal description of the property. The grantor, meaning the current owner, will sign the document, the deed, in front of a notary, and the ownership or the deed is recorded in the Register of Deeds. And that's significant because that does create a public record of who owns the property. It's something that anyone can go back and reference to see who owns the property. And again, when people are passing away owning property, the ownership is transferring by virtue of the person passing away or the people in the family passing away. There's just no record of it. There are a lot of questions in the registrations about deeds and how they work and how do you add someone to a deed. That's not actually how it works. A deed is used to perform the act of transferring the property. It's not used to maintain an ongoing record of who the new owners are. So we'll talk about that a little bit later, but I did want to point that out that question came up a lot for folks. So property doesn't begin as heirs property. Usually you have an individual or a couple who acquire the land by deed, and they own it while they're alive, and then they pass it on when they pass. They transfer ownership through inheritance when they pass away. So for purposes of today, let's imagine that we have a married couple, and they live in North Carolina. They have 4 children, and when they got married, they purchased 40 acres. So married couple purchases 40 acres of land, built their family home on it, and they have 4 children. All right. So again, let's use our chat box. Who becomes the owner of the property when the first spouse passes away? The other spouse. Yeah, surviving spouse, correct. And that's automatic. So when married couples acquire land, they acquire it as tenants by the entirety. That's an automatic. It's tenants by the entirety. And that type of ownership comes with an automatic right of survivorship. And so, yes, in this scenario, when the first spouse passes away, the surviving spouse becomes the owner. What about when the surviving spouse passes away? Let's say that, like many Americans, neither spouse had a will, and now the surviving spouse has passed away. Who becomes the owner of the property, and what do they get? Again, let's use the chat box. Yes, okay, the children, the heirs. So folks are indicating that the children are the heirs. That's correct. What do they get? What do the 4 children get? Okay, so we have, someone says each child gets a quarter interest, an equal share. All right, 25%. So do they each get 10 acres? Oh, no text yet. Okay, so someone has said they get 10 acres. Someone said no. That's correct. So it's an undivided interest. Yes, we got some smart folks on here. Are y'all lawyers? You don't have to answer that right now. I'm just impressed. I'll say that. So yes, our children, our 4 children, get a 1/4 share. That's an undivided interest in the property. And that's significant because it means that they all are entitled to use of the 40 acres. They're all responsible for the property proportional to their share, both financially and legally. And it doesn't physically divide the property. A lot of people believe that when you have property being inherited by multiple people, that those individuals are entitled to specific acreage, and that's not the case. In fact, they all are entitled to the whole property. So let's look at a family tree over time. Our family has grown. We have the original owners, which are the top 2 boxes in blue. And then the next row is in lilac is the 4 children. 3 of the children got married. That's the yellow boxes. And then all of the children had children. So there's some grandchildren. And then there's even some great-grandchildren, as illustrated by the bottom row. And that's normal. Families grow. Now let's imagine that all of the family members who have an X in their box have passed away. Let's also imagine that they passed away without a will, and that the original owners, the parents, passed first, their children passed next, the 2 spouses that passed away after their spouses, and then the grandchildren who passed away after their parents. So from the top to the bottom, that's the order of the deaths in the family, and that's everyone who has an X in their box. Based on your understanding of the law in North Carolina, so no will, based on your understanding of the law in North Carolina, how many owners do you think we have today? Again, let's use the chat box. Too many. 8, 9. Anyone else? Any other thoughts? We have too many, 8, 9, 12, everyone. I'm thinking that they meant everyone. We have 16. So you're proving one thing, and that's that we all don't agree on. We don't agree on the same number, which is common among families. People have different interpretations of the law or different understandings of how the law works. And so, yeah, there could be different views on who the current owners are. But in North Carolina, if under this scenario, there are 16 owners. And that's significant because we went from 2 owners to 1 owner to 16 a couple of generations later. And that has to do with our intestate succession laws. So in this family, like many families, there were no wills. And even if they had wills, it's very likely that they would have duplicated the same kind of results because through the wills, people often leave property to multiple people. But looking at our intestate succession laws, this is a set of laws that comes into play when you do not have a will. So if you don't have a plan, the state has a plan for you and your property. So if you die with children but no spouse, it's pretty straightforward. The children inherit everything. If you have spouse but no descendants, so no children, grandchildren, etc., and no parents, then your spouse inherits everything. Then it gets a little bit more complicated. If you are survived by a spouse and one child or the descendant of one child, the spouse gets half and the child or descendants of one child inherit half of your real estate. And then if you have a spouse with two or more children or descendants of those children, the spouse gets 1/3 and the children get a 2/3 share that they split depending on how many children there are. And then it gets even more complicated. So if you don't have children or descendants, but your parents and your spouse are living, then it's half-half or 50-50 between your parents and spouse. And then if you have no spouse, no descendants, but your parents are living, then your parents inherit it. And if you have no spouse, no descendants, and your parents are deceased, then your siblings or the survivors of your siblings inherit your real estate. So it can get pretty complicated, and it really just depends on when someone dies and who survives them. So not a lot of predictability, well, not any predictability at all, actually. So heirs property owners own the property as what's called tenants in common. Oh, someone had a question. There are many owners, but there is still 25% interest based on original owners. Yeah, so to your question, Paulette, the 1/4 shares that each of our, going back to the map, the tree, our siblings, the 4 siblings, they had 1/4 shares. Their 1/4 shares are then divided based on who succeeded them in ownership. So in this case, on the far left, their 1/4 share was then divided into 4s. So their heirs ultimately received a 1/16 share. Compare that to the far right, where we have a 1/4 share being divided by 2, then they have a 1/8 share. So the fractions can get pretty funky depending on each person's heir. So heirs property is owned as tenants in common. Remember, I said earlier that when married couples acquire land, they own the property as tenants by the entirety. With heirs property, they own it as tenants in common. And that's the same kind of treatment, the same legal rights as if all of us on this call, all 71 of us, were to acquire property together. We would also own it as tenants in common, even though we're not married. So they treat heirs property, they treat family land the same way they treat land owned by individuals who are unrelated, which kind of makes it difficult for families to keep land in the family and to manage it together, which I'm sure many of you are familiar with the challenges. Any of the owners has the right to transfer their share to a third party. They don't need permission of the other owners to transfer their own share. Any owner can, any legal decisions that are made about property, even something as simple as whether to provide a hunting license on the property, but it could be even something as complex as whether to sell the property or to borrow against the property. It requires unanimous decision-making among the owners. And again, if we have numerous owners, whether it's 3 owners or 16 owners or 71 owners, it requires unanimous decision-making. Any owner also has the right to seek physical division of the property, which is called partition. And if someone is interested in physically dividing the property, again, they could do that if there's a unanimous agreement among all the owners. However, if there's not agreement among the owners, any of the co-owners can go to court to seek a physical division of the property. If the court cannot divide the property equitably, meaning that if they can't divide it proportional to each owner's share and the characteristics of the land are not consistent across the property, then the court has to force the sale of the property. That's called a partition sale. And that's where we get into land loss. A lot of times, partition sale actions are brought by third parties who purchase a share of a family member's heirs property and then uses their legal right to seek a forced sale of the property. And that's what's contributed. That's what's contributed to a lot of families losing property in North Carolina and South Carolina, Georgia. A lot of times when we hear about Black land loss related to heirs property the loss along the coast of South Carolina and Georgia is often referenced because many of the families that were enslaved acquired a lot of land along the coast in the Sea Islands of South Carolina and Georgia. And then when those areas became desirable for vacation resorts and so forth, real estate developers, unscrupulous folks came in and bought shares, sometimes under duress, from individual owners and forced to sell the property and were able to acquire it at auction. So the legal structure of heirs property is very challenging in that it can be a source of conflict, it can make it difficult to manage the property, and it can even result in loss. There are also social challenges with heirs property. Folks are becoming co-owners of property together, and they may not have chosen to co-own property together with other folks. They may not have good relationships or communication. They may not even know the family members. And so it can create challenges. Oftentimes you'll have co-owners who are taking responsibility to keep the property up and make sure it's taken care of, and take care of things like property taxes or pay the mortgage so that the property stays in the family, and other family members aren't doing anything at all. And it builds resentment and can create a lot of rife amongst family members. And then the financial aspect of it could be challenging for folks. You're becoming an owner involuntarily, and by law, you are legally responsible for the property and financially responsible for the property. So things can get really complex.
Here's a question in the chat.
Yes.
It's, can a sibling without children leave their portion to their niece and nephew?
Yeah, so any owner can transfer their share to whomever they want while they're alive. And if they have an estate plan that includes a will or trust, for example, they can provide the property, their share of the property goes to whomever they want, whether it's niece, nephew, Mavis, Pamela, Alton. So yes, you can transfer your share to whomever you want. Someone mentioned the Torrens Act of 1868. So the Torrens Act is a very archaic law that we have in North Carolina, and it exists in other states as well. But it has to do with clearing title and asserting rights on property. I won't go into it deeply, but I will say that it has been used as an abusive practice as it relates to family-owned land, even among family members. Some of you may have seen or read an article that came out a couple of years ago, or maybe last year, about a family where one family member was able to get ownership of the property in their name solely using the Torrens Act. I'm hoping North Carolina will do away with it, because it really only has been used for negative things in the present times.
We have another question.
Oh yeah. Okay.
If there is a lien or judgment against a property owner, can he or she be forced to sell his or her interest?
Oh, that's a great question. So that's another aspect of the financial challenges with heirs property and the legal structure, is that creditors of any owner can attach a lien against that owner's share. They can't force the sale of the property, but if the property is ever sold, or if there's any income on the property, legally that creditor has to be paid. And again, it's proportional to, it's directly connected to that owner's share. Really depending on the value of the property and the amount of debt, the likelihood that a creditor would attach to heirs property. And again, because many people, there's not really a strong record of, a lot of heirs property doesn't have a clear public record of how the ownership is transferred. So it's legally possible, but it really depends on the circumstances and whether a creditor was able to find out. So an example I could think of is if there was an estate for a deceased person, and their share of the heirs property was listed on that estate, and then through the estate process, the creditor became aware of that. There's still some hurdles that have to be met before the creditor can get a judgment against real property, but technically it is possible. Great question. All right, So how do we make family land ownership work? Ideally, we're going to put ownership into a single entity and create the management structure that is suitable for our family, our land, and for future generations. And so one type of entity that you could use is a trust, and Pamela is going to talk to us more in depth about trust later. Another entity that you can use is a limited liability company, or a family partnership. There's various business entities that you can use, but most commonly we think about limited liability companies as a good model for succession planning for family-owned land. In a limited liability company, you have the company is created by filing the appropriate paperwork with the state of North Carolina, and the current family member owners will transfer their shares into the limited liability company. So the company owns the real estate, and then the family members own the company, and the family members will sign what's called an operating agreement. And I should note that you're not required to have an operating agreement in order to create an LLC, but there's no sense in creating an LLC if you don't have an operating agreement, because that's the heart of what makes an LLC useful for managing intergenerational family land. That operating agreement is the document that's going to govern how the property is managed, who's in charge of the day-to-day, and what kind of decisions they can make, what kind of decisions can the owners make, what happens with the share of any owner who passes away, or if they no longer want to be an owner. So the operating agreement is key to a limited liability company. And again, Pam is going to speak later about how trust works, and we can make the connections for trust with heirs property at that time. However, the entity, while the entity is the goal, it's not the first step. The first step is confirming who the legal owners are. And for many families, we have to start with the family tree. The family tree descending from the original owners or the owners on the last deed of record all the way to the youngest generation in the family. So it's not your typical family tree. Instead, it's a family tree that is aligned with the original owners of the property, or the last deed of record that reflects the owners of the property, and then tracing the family tree from them to the youngest generation, being very inclusive. And I know families are dynamic, and there's people we consider family and people we don't consider family, but you want to include everyone. You want to include quote unquote adopted people, people who are legally adopted or socially adopted. You want to include people who are born of a marriage, people who are not born of a marriage. You want to include spouses. You want to include everyone, as many people as possible, everyone in the family. Don't make the decision of who you don't like or you don't think is family. Leave that up for the attorneys. But you want to include for each person who has passed away, their date of death, where they passed away, whether an estate was administered, and who survived them. And I know that's a lot of information, but it's really important information, and you should try to get as much information along those lines as possible for everyone who's passed away. So again, in the family tree, we want to trace from the last deed of record to the youngest generation of family members. We want to be very inclusive. And for anyone who's deceased, we want to know when they died, where they died, whether an estate was administered for them, and who survived them. And I recognize that it may not be possible to get all of that information. There may be some gaps, but to your best ability, you want to have as comprehensive a family tree as possible. And then once you have that family tree, then you want to go to an attorney. So you don't want to come to an attorney first, because you don't want to pay an attorney to do the family tree. But the attorney can actually rely heavily on the family tree to build the chronology of the family's land ownership. And so when you go to the attorney with your family tree, your ask is that they complete what's called a title search and form a legal opinion of who the current owners are. If you've ever purchased your own house or property, part of that process of purchasing was having an attorney do a title search. In this case, the period or the scope of the title search really is informed by the family tree and when the property came into the family. So it's important to work with an attorney who is very familiar with real estate and estate law, and to work with someone who's willing to have some flexibility with how you work with them. I don't think you should go to an attorney and say, hey, I want you to put this property, we want to put this heirs property into a trust or LLC. And then the attorney say, hey, okay, give me $5,000 and then we'll just bill against that. And then they come back and say, give me $5,000 more. No, I think first you should limit the scope to the title search, and you may even want to limit the scope of the title search to a set number of hours. When I have my practice, I would suggest that you give me enough money to cover our first meetings and 5 hours to perform the title search. When I have spent 5 hours on your matter, that's a check-in point. That's a benchmark for us to see where we are and whether it looks possible to continue on that journey towards the single entity. You may find that the goal that you're seeking is not possible, and that you have to instead develop a different strategy, such as using legal action to confirm who the owners are. And I'll talk about that in a minute. But once you have a confirmed opinion from an attorney of who the current owners are, then those owners need to have a discussion and make decisions about the property. And it may be that you have people who want to continue to be owners or continue to be connected with the property, and people who don't want to continue to be connected with the property. And so I think it's important to be really strategic in having those conversations. Maybe you need to bring in a third party as a mediator or a facilitator to hold the discussion, because, you know, depending on the family dynamic, it could be a very difficult discussion to have and to facilitate. And there are professionals who can offer group facilitation services to take that burden of the facilitating the process off your shoulders so that you can just participate fully as an owner. But in that decision-making and discussion, it's important to identify who's going to remain involved, who's not going to remain involved. What are the long-term goals for the land and how it's used, et cetera, and then have the attorney counsel you on the ownership structure that's most suitable for those goals and the decisions that the family is going to make. Of course, there are alternatives to putting ownership into a single entity owner. You could always maintain the current situation, which a lot of people do because it does feel overwhelming. You could enter into what's called a tenants in common agreement. So that's a contract between the owners around how the property is used and who can use it, et cetera. And you could even agree to a different voting structure instead of unanimous voting. But the tenants in common agreement is not necessarily going to survive past the current owners, and you'll have to, when owners pass away, you'll have to ensure that the new owners, new co-owners, are in agreement with the tenants in common agreement. So it's not ideal, but it is something that could at least be a placeholder while you address some of the other issues, such as what type of entity to use, and so forth. And then, of course, you could physically divide the land. One thing that I don't like among my peers, my fellow attorneys who work with heirs property owners, is that they often go to this solution that they, you know, if there's multiple owners, it's confusing, people may not like each other, let's just divide the property up. And I'm sure Alton and his crew can tell you and have told you before, if you divide the land, the value, the economic value is also divided and decreased. You know, harvesting timber off of 25 acres versus harvesting timber off of 8 acres is a big difference, even if they're considered smaller parcels. So it's not ideal to physically divide the land, and it's certainly not ideal to go to court. When you go to court, if you have a co-owner who says, you know what, I don't get along with them, I want to go to court and I want the court to divide the land, or I want the court to sell the land, you're putting the decisions into the hands of someone who knows nothing about your land and probably doesn't care about you or your land. They're just tasked with making decisions around whether the property can be divided equitably, whether the property should be sold at auction because it can't be divided equitably. And I just want you all to think about, you know, where what county your land is located in, and do you know the clerk of court? The clerk of court is the person in North Carolina who makes the decisions about partition actions. And so usually the clerk of court isn't really looking, I mean, I'm not saying clerks of court are bad people, but they have a task. Their task is to find a resolution based on the law. And they're not going to necessarily take into consideration how hard your grandparents worked to get the land and how the land fed you and helped you go to college. And so that's why I think it's best to avoid that, that action. And there are a lot of incentives to address the legal challenges. I'm assuming that many of you here are familiar with one of the first incentives, which is, forestry and traditional agriculture and conservation opportunities. Land is, when you have acreage, you have multiple acres, there's benefits to not only your family, but your community and your state, related to conservation, related to carbon sequestration. And so it's important to think about the natural characteristics of your land and how that can benefit not only you and your family, but those around us. There's also intergenerational wealth and stability to consider with family land. For many families, a lot of their wealth is situated in land. Even if the land itself isn't of high value, the fact that it's part or a significant part of the family's intergenerational wealth is significant, and it's something that should be cared for. You also, when you address the legal challenges, particularly clearing title, clearing the ownership, and confirming who the current legal owners are, will be able to gain access to resources, including disaster recovery. In North Carolina, the disaster recovery / mitigation plan, in its first iteration, did not actually have mechanisms to support heirs property in disaster recovery because you can't prove that you own it. They have made some adjustments, but it only goes back one generation. So if you have heirs property that you inherited from the last owner that's on a deed of record, then you could access the disaster recovery. But if it goes back further than that, at least my interpretation of the plan is that it does not, you cannot qualify for it. And that includes other disaster recovery such as FEMA. You cannot get FEMA benefits if you do not have clear title, and that is something that harms many heirs property owners. And then, of course, you can't confirm legal standing to address environmental justice and other issues. If you can't prove that you own the land, then if your neighbor is spraying hog waste on your land, you can't sue them. Well, there's other reasons why you can't sue them because our statutes are bad, but if you can't prove you own the land, you don't have legal standing to sue them. And that could even be a boundary dispute. So it's really, there's a lot of reasons why you should address the legal challenges, even if they feel insurmountable. I just want to show you this map, these two maps of North Carolina to go along with this discussion about environmental justice and so forth. This map illustrates heirs property across the state of North Carolina. The red, that's indicating heirs property across the state of North Carolina. So if we take a look in the northeastern part of the state, there is a significant amount of heirs property. And then it's overlaid with data around the proportion of Black residents in each of our counties. And again, if we look in the area where Roanoke Electric is, it's very Black and lots of heirs property, except I don't know what the one county is in the middle that kind of doesn't have a lot of heirs property. It may be that we don't have enough data from that county, but that's significant. So there's a lot of heirs property where many of our Black families live. And then let's look at this map. It's blurry, I apologize, but this map basically illustrates all of the coal ash sites in North Carolina, all of the confined animal feeding operations, the Atlantic Coast Pipeline, which is no longer being pursued, and then coastal flooding. So again, thinking about where heirs property owners or where heirs property is in North Carolina, or where there's lots of heirs property and where there's lots of potential or actual environmental injustice, that's pretty significant. That's a lot of land that cannot be defended if there's some sort of environmental justice. So, again, just looking at both maps, there's significant intersections with ownership of land and where some of these impactful environmental activities occur. So there are initiatives and policy that support heirs property preservation, including the Sustainable Forestry and African American Land Retention Project, of which Roanoke Electric was one of the first sites. We call them we call the organizations that do the on-the-ground work with the landowners SFLR sites, and Roanoke Electric was one of the first ones, and has been tremendous. And what's wonderful about Roanoke Electric is that they've extended this program to all of their members. There's also the Land Loss Prevention Project, which is a nonprofit law firm representing Black landowners. They've done a lot of work with Black farmers who were discriminated against by USDA back in the day. There's the Uniform Partition of Heirs Property Act. So remember the partition actions that I mentioned before, where an owner can go to court and say, hey, we want the property divided, or we want it forced at auction. The Uniform Partition of Heirs Property Act provides some additional due process rights when it comes to family-owned lands, meaning that if heirs property is subject to a partition action, there's certain considerations. For example, the petitioning owner has to offer their share to the other owners at fair market value. And if they don't purchase the share of the petitioning owner or owners, and the property is sold, the property has to be sold at fair market value. That legislation has been adopted in 17 jurisdictions. So 16 states and the U.S. Virgin Islands have adopted this legislation. North Carolina has not yet adopted that. Alston and I have been part of a coalition of North Carolina organizations that are seeking to get this legislation passed this year. And the wonderful thing about this legislation is, in addition to the due process rights that it gives heirs property owners, there's also a connection to access to resources in the U.S. Farm, or through USDA, which was mandated under the 2018 Farm Bill. So the 2018 Farm Bill had provisions for getting a farm and tract number. So historically, heirs property owners have not been able to get a farm and tract number if they cannot confirm or prove that they own the property. So that cut off access for a lot of people. Well, with the 2018 Farm Bill, it says if you are in a state where where the Uniform Partition of Heirs Property Act has been passed, then here are the documents that are required to get the farm and tract number. If you're in a state that has not adopted it, then the regulations lay out how that happens. And I'm not quite sure what those regulations say. They just only recently came out 2 years later. So those two things are really positive for heirs property owners. And I think we're seeing even more legislation in Virginia. They just, they're about to get new legislation where if there's delinquent property taxes, there's certain, and it involves heirs property, there's additional requirements of the municipality before the property can be foreclosed on. So that's good. And hopefully we'll get legislation like that in North Carolina one day. And then North Carolina Legal Aid. Oh, sorry.
No worries. We have some questions. One is particularly related to the bill you were just discussing. They asked, has a numbered bill been introduced for the Uniform Partition of Heirs Property Act?
Has the bill been introduced? Not yet. I think, Alton, correct me if I'm wrong, I think the plan is to begin that process next month.
Yes, that's correct, Mavis. It has not been introduced yet. The coalition is currently working on strategies to introduce it in the long session.
Yeah. Another question is, if the land is partitioned, does the family members have a say in which portions they receive? Mm-hmm. So that depends. If the partition action is voluntary, not partition action, if the physical division of the land is voluntary, meaning that all of the owners agree to physically divide it, then yes, then they can decide how they divide it up. But if it goes through the court, that power is stripped away. Instead, the court is going to appoint commissioners. They're called commissioners. They're going to appoint 3 people who are tasked with determining how it's divided up. And those 3 people are going to work with appraisers and surveyors and so forth and make a determination of whether it can be divided equitably, proportional to everyone's share. And if it can, then they will decide how it's done.
Okay. We also have 2 questions about LLCs that were posted. Can you legally keep spouses from having an ownership share if an owner is married? That's one. You might want to address that one first. And then do
Okay,
owners...
can you?
Go ahead.
Sorry, go ahead. No, go ahead.
I was just going to go over the second question. You see it?
Oh, okay. I see. Yeah, I do. So one question